Good morning, everybody. I'm Richard Ottinger, President of the Virginia Bar Association. Welcome to our 29th COVID call as the VBA addresses issues of concern to lawyers across the Commonwealth during the pandemic. I had sincerely hoped that when we return to our calls following our summer break, we would be able to rename them, but unfortunately, the Delta variant had different plans for us. So we're still going to address COVID hot topics in these calls, but we're going to hopefully start moving away from that exclusively and move towards some more general topics of interest for our membership. So this month we have 5 great speakers. First, we'll hear from former chair of the Labor Employment section and my partner at Vandeventer Black here in Norfolk, Arlene Klinedinst, who's going to give us the current status of vaccine mandates in the workplace and some practical scenarios that will help guide our clients as well as our own firms. And obviously that topic got some attention from President Biden yesterday. Next, I'm excited to have the very soon to be new executive director of the Virginia Bar Association, Paul Fletcher, with us. Paul's going to introduce himself and give us his thoughts on sort of his immediate plans for the VBA. Third, we will hear from our good friend, Jeff Palmore, the VBA's super lobbyist from Reed Smith's Richmond office, who will fill us in on all the important happenings in Richmond since our last call, which was in May, and what he expects for the fall and the upcoming legislative session. And finally, we'll hear from Hunton Andrews Kurth's Chip Nunley, and if I'm saying this right, Michaela Ross, who is Hunton's Churchill Pro Bono Fellow. And they're going to talk to us about the current status of residential evictions and the moratoria on those and practical rent relief options for landlords, residential landlords. But first, I'd like to run through a couple of typical housekeeping announcements and disclaimers. While Paul Fletcher has not formally left Virginia Lawyers Weekly, he is not appearing on today's Zoom on behalf of Virginia Lawyers Weekly, and he doesn't expect any reporters to be on the Zoom. That may resume in the fall, and if it does, we'll have our typical disclaimer about comments and attribution. This call is not meant to be the rendering of legal advice. This is an exchange of information relative to our profession. There should be no expectation of any attorney-client relationship with respect to anything said on this call. You should retain the services of competent legal counsel as necessary. The same holds true for resources on the VBA's website. Be sure to do your own due diligence on any of this information. So if you could please place your microphones on mute. If you have a question, please raise your hand, or if you're on the phone, unmute and try to pose your question, and then put your phone back on mute once you ask your question. Please let us know who you are and where you practice. With today's packed agenda, it may be tough to get through. If so, feel free to drop your question into the chat on the Zoom or email your question to me at rottinger@vanblacklaw.com, rottinger@vanblacklaw.com. As always, I'll try my best to keep an eye on those questions and hopefully get to those. Without any further ado, let's hear from Arlene Klinedinst.
Hello, good morning, everybody. I'm going to just take a few minutes to go over the current state of the law on COVID vaccine requirements for employers. As Richard said, I normally represent employers and advise employers on how to comply with the law. And as any other labor and employment lawyer knows, or any lawyer for that matter, with the COVID, we've just been getting question after question on what do we do, how do we comply, how do we keep everybody safe, what happens when people refuse to get vaccinated. And the basic answer for employers in Virginia is that they can require vaccinations. of their employees under Virginia law and federal law, as long as they allow for two limited exceptions. Those two exceptions are if the employee states that he or she has a disability and his or her doctor has recommended that because of that disability, they cannot get vaccinated. So, and I apologize for the background noise here. As luck would have it, I'm having a hot water heater replaced today. So that gave out. So please pardon the noise in the background. But in any event, there are two exceptions to employers requiring vaccines. If the employer has a disability that prevents them from getting vaccinated, or if they have a sincerely held religious belief that prevents them from getting vaccinated. So if an employee says they either have a sincerely held religious belief or they have a disability and that's why they can't get vaccinated, then the employer can require documentation of either one of those reasons, and then the employer's duty is to reasonably accommodate that either disability or sincere religious belief, and then the burden shifts back, and the employer, this reasonable accommodation language comes from the Americans with Disabilities Act, the Virginians with Disabilities Act, and from Title VII, which requires covered employers to reasonably accommodate religious practices or beliefs. So this reasonable accommodation, so to speak, is not unlimited. So it doesn't mean if, let's say, an employer decides to require vaccines and somebody says, well, I have a disability, I have a sincerely held religious belief, it doesn't mean that your hands are tied. You as the employer then go to the analysis of, can I reasonably accommodate this disability or belief? Or is it an undue burden on my business? So you can do that analysis as long as the employer does that analysis, documents it. They're not going to violate those laws. The other analysis is, does this reasonable accommodation create a direct threat to the health and safety of the employee or to others? So this is where I think, especially with the COVID vaccine issue, if you have a healthcare worker, you have a worker who has to have close physical contact with other people, whether it's customers, employees, whatever, then somebody who's unvaccinated, I can see a good argument being made that it is a direct threat to the health and safety either of that individual, your employee, or to others, to have an unvaccinated worker working in close proximity, whether it's, you know, a medical setting or whatever. So anyway, that's the law on requiring vaccines as it is. Now in comes President Biden with the executive order that he issued yesterday, saying that now OSHA is going to enforce these new rules. And most of you have probably heard this on the news, but and let me back up. Governor Northam already stepped in, as you know, and required state employees or state government contractors to have vaccine requirements. So we've been seeing that for a while with our clients, asking questions about, you know, what if we have employees who are working at state agencies, or we have government contracts. Again, the vaccine requirements are valid, and you have to comply with them if you're a state contractor or now a federal government contractor, or As of yesterday, if you're an employer with 100 or more employees, you are going to be required to require vaccines. And again, these two exceptions will still apply, and you have to do the reasonable accommodation analysis. And there is a caveat if somebody cannot get vaccinated, and this applies to the 100 to the new requirement for private employers with 100 employees or more. You can, if somebody cannot get vaccinated because of those two reasons, then you are supposed to require testing, proof of testing, COVID testing every week. So that's the new law effective immediately, and OSHA is going to be monitoring this going forward. Another key takeaway from yesterday's executive order is paid time off. Right now, there is no federal or state law in Virginia that requires employers to give paid time off for sick or whatever. There is the federal paid sick leave law that applies to certain government contractors, but just your run-of-the-mill everyday private employer doesn't have to give paid sick leave, although many people or many employers do. But now with this new law, if you're an employer with 100 or more employees, you have to give paid time off for employees to go get vaccinated or to go with a loved one, a family member who's getting vaccinated. So that's a new PTO, paid time off requirement that didn't exist before yesterday. Healthcare workers are also going to be required to get vaccinated, and there are no exceptions for them, from what I understand. Now, the executive order itself is now out online. The OSHA rules are not out yet, obviously, but that's something that everybody should keep watching. Richard will have to cut me off too. I know we have a lot of speakers, but Richard wanted me to address a couple examples, and I'm happy to answer any questions that may come up, but we've had a couple of real life examples from our clients that are worth noting. We have one infamous client who will remain nameless who decided that he, the owner of the company, was going to require vaccines, and which you can do legally. And then everybody who refused to get a vaccine, he would bring them into his office and show the person printout after printout of CDC guidelines and all the testing material that the FDA required, and basically woodshed the employee and convince until they were convinced, okay, enough, I'm going to go get vaccinated. And so he wanted to know, is this legal? And as far as we can tell, it's legal. There was no false imprisonment. The employee could have left at any time, but that's just one way some of our clients have been trying to get their employees to get vaccinated. We've all heard about the monetary and other incentives, which are all perfectly legal too. But now it looks like if you have 100 or more employees, that's going to be the law. And you can discipline or discharge employees if they refuse to get vaccinated and they don't have a legitimate disability or religious belief. And even if they have a legitimate disability or religious belief that prevents them from getting vaccinated, if it's an undue threat to the person's, to the employee's health and safety, or to others' health and safety, you can say, I'm sorry, we don't have any other work for you. And we have seen this come up with some of our clients who have employees that have to go work in the federal environment or a healthcare environment where vaccines are required. And if that person, say, even has a disability that prevents them from getting vaccinated, we can't, the employer, the client can't send that person to do that job. They're not qualified and there's no other job for them to do. So they can at that point lay that person off, or, you know, put that person on temporary leave, or even discharge the person. So
Arlene, quick question on that point. How about a half measure? Let's say an employee, a reasonable accommodation would be sending the employee home to work from home, but they can only do, let's say, half of their actual work. Can an employer then, in that scenario, keep that employee on and pay them half?
Yeah, that would be legal, provided you're not violating any other rules. Remember that if that person is an exempt employee under Fair Labor Standards Act, a salaried exempt employee, you may not be able to cut his or her pay, weekly salary, fixed weekly salary based on the number of hours that he or she can work. If it's an hourly employee, then certainly that's fine. If it's a salaried exempt employee, then you may have to make some changes, maybe change them into an hourly non-exempt employee during the period of time when they can only work part-time. But there are options like that available to employers that are perfectly legal under these rules.
Fantastic. All right. Any other questions from anybody for Arlene? All right. Hearing none. Arlene, thank you so much. I really appreciate it.
Sure.
Great job. All right. Next, Paul.
All right. Thank you, Richard. Good morning, everybody. I am thrilled to be here, thrilled to be joining the VBA on September the 20th. Many of you may know me from Virginia Lawyers Weekly. That's where I've been for the past 33 years. Before that, I practiced law down in Southwest Virginia, a firm with offices in Abingdon and Bristol, and I did a lot of employment law and commercial stuff. I've always continued to be, Arlene, appreciate the rundown. I've always been continued following employment law. I've been the employment law bureau chief in the office. I've also been the insurance law bureau chief in the office, mostly because nobody else wanted it. So I took that. But I have had a chance as a lawyer journalist to do a lot of observation of bar groups, particularly those here in Virginia. And I've known and followed a lot of executive directors at the different groups, Yvonne Cockrum and Breck Arrington, Guy Tower at the VBA, Jack Harris, Valerie O'Brien at the VTLA, and then Lee Farmer and Sharma Mather, who actually used to work with me over at the VADA. So I've gotten a good sense of how they do their jobs, how they work with their boards. And I've actually had a chance from the inside. I was on the national leadership ladder of the Society of Professional Journalists a number of years ago, and worked with a board there and a great executive director. So I've had a chance to make a lot of mental notes about what I want to do once I get on board. And I'm very grateful to the search committee and to the board for giving me this opportunity. So thank you. I expect to be very busy starting September the 20th. I know it's a busy time for the VBA. There are a lot of different programs going on, which should be a great way to get acclimated quickly. Jeff, I appreciate your reaching out to me already. I look forward to meeting with you in person and working on advocacy matters. I think that's a critical part of what the VBA can do. I expect to spend a good amount of my time looking at membership, because I know Richard made that one of the themes of his presidency, and Ryan Boggs has a committee that is meeting next week that I'll have a chance to join that discussion. And I am excited about doing that because one of my favorite parts of my job at Lawyers Weekly was circulation, and trying to get somebody to buy a subscription and trying to get somebody to join a voluntary bar group is a pretty good match, and it has some of the same concerns for retention, attraction, retention, all those kinds of things. My wheelhouse, of course, is communications, and I look forward to working with Marilyn Shaw on the website once I get on board, taking a look at some of the newsletters, how we get information out to members, because I think it's important to make sure people know what we're doing. And once we get the advocacy list up and running, to make sure people are aware of what it is that we're advocating on their behalf on Capitol Hill. And I think I'm really looking forward to working with Kalina Robb as she completes her term as chair of the Law Practice Management Division, and then Michael Guanzon once he takes over. Because I think one of the key things that the VBA can do is things just like this call that Allison McKee started last year and that Richard, you've continued. I think this is a wonderful service to help people practice law better and more efficiently, and to help them in their work. And that to me is one of the key things the VBA can do. So I'm excited. I look forward to hearing from a lot of people once I'm actually in the saddle. So thank you.
Fantastic, Paul. Anybody have any questions for Paul? I did get a note from the current VSB president, Jay Meyerson, who wanted me to pass along his congratulations and welcome you aboard the VBA.
Thank you. Appreciate that.
All right, and if there's no questions, we will move on to Jeff Palmore.
Thank you, Richard, and welcome, Paul. Look forward to working with you. Going to give a brief kind of look back at what's happened since our last discussion, but then also a look forward to what's in store with the legislature and the executive branch over the next several months. So last month, the General Assembly was in town for a special session that focused really on two main issues. They were allocating ARPA funds and appropriating those monies into a number of priorities that the governor and the General Assembly agreed on. Those were things like school ventilation in K-12 schools. They put money into the unemployment funds. There were a number of other priorities like rental assistance and small business assistance that they appropriated money for. And then, as many of the folks on the call know, they selected a number of new Court of Appeals judges. And there were 8 new slots in the Court of Appeals, 7 new ones from the expanded, and then filling the seat from Rossi Alston. So they picked a group of judges, new judges from around the state. Some of those have already taken the bench, and then some of them will be phased in over the next couple of months. And then the new Court of Appeals jurisdiction will be expanded at the end of the year. Something that's going on right now, because we are at the beginning of a new decade as the redistricting process. So that's a process that takes place every 10 years. The census numbers were a little late coming in, so we weren't able to get started as quickly as we had hoped. But the redistricting process is underway, and it's a little different this year because of a constitutional amendment that the General Assembly passed and voters approved. So there's a redistricting commission that is meeting right now, made up of citizens and legislators to see if they can agree on new districts for the House of Delegates, the Senate of Virginia, and then the Virginia's congressional seats. And if those districts, once the commission, if they're able to draw them, they'll go to the legislature for an up or down vote. If they can't agree on those new district lines, then it will go to the Supreme Court of Virginia for them to draw the new lines. So it's going to be interesting to see that play out over the next month or so, but that's going to have a big impact on the elections, not this year, but in future years for the House and the Senate. On the topic of elections, we are under 2 months away from the election, and early voting will get started here in the next couple of days. All 100 seats in the House are up for election, as well as the statewide races, governor, lieutenant governor, attorney general, and all of those are highly contested. In the majority in the House that's currently held by Democrats. Republicans are hoping to retake the majority in the House by winning a couple of targeted seats around the state. So we're going to be watching those elections closely over the next 2 months. And then we are looking ahead to the 2022 regular General Assembly session. We are hoping that it will be all in person with people from the public and within the lobbyist community being able to participate in person. Last session was all virtual, which presented a number of challenges in being able to participate in the process. But that session starts on January 12th, the second Wednesday of January, and will be a 60-day session. They'll need to write a new budget, so it's a long session year. And so we within the VBA have our legislative day, Board of Governors meeting on the 23rd. That's going to be a Zoom meeting where the Board of Governors will meet and then hear from sections about legislation that they want to present to the board for consideration. I know we just got one proposal in this morning, and several others are in the works. So we're going to have a number of ideas for legislation from our sections that the Board of Governors will consider for the VBA to take on and run with this coming General Assembly session. That, as Paul said, that's an important part of the VBA's mission is advocacy, and we at Reed Smith are glad to be able to help with that process and work on shepherding those bills through the legislative process. So happy to answer any questions that anybody might have, but that's where things stand right now.
Fantastic. Thanks, Jeff. On that point of Legislative Day, just another plug for that. If any of the participants on the phone have any issues that they are aware of, that they think the VBA may be interested in advocating for or against in the upcoming session, just reach out to your section chairs and let them know what the issue is, and let them give them an opportunity to put it in the works in the next couple weeks. And we'll get on it, and understand that Jeff is on a flat fee, so the more the better.
Hey.
All right, any other questions for Jeff? All right, hearing none. Thanks, Jeff. Appreciate it as always. All right, last but not least, wanted to introduce Chip and Michaela Ross and let them talk about the current status of residential evictions and rent relief, and let them know that they've got 30 minutes to play with. So have that. Don't feel obligated to fill the time, but there's no time pressure on you to speak quickly or cut yourself short.
Great. Thanks, Richard. When Richard invited me to speak, I said on one condition, and that was that I could have Michaela join me. And you'll see soon, I think, very abundantly why I made that a condition. We're going to talk about eviction, and eviction is can be, from the lawyer's standpoint, a little bit of a sterile process. It's a very legal process leading up to it. And the lawyers stay very involved in the process, generally up to the very end. But to sort of set the tone for what evictions mean, I'd like you to, if you can even conceive this, imagine that you woke up this morning to a knock at your door, opened the door, and there was a yellow piece of paper on the door that the sheriff was taping, and it was a writ of eviction. And basically what it told you was that you had 72 hours to move everything that you have in those premises, be it a house or an apartment or whatever, out. And also kind of contemplate that without, the benefit that most of us have of money in the bank and a checking account and that sort of thing. But imagine you faced that with really no resources, and you had to make a decision between, do I take what money I have and try to put perhaps a 2-month down security deposit somewhere, come up with the first month's rent? How am I going to get money to move? If I don't have a place to go, which is right now, there are very few places to move into. The market is extremely tight. Can I afford to put my belongings into storage? And what's it going to mean to if I have school-age kids, what's going to happen to them in terms of where I am, and are they going to be able to continue to go to their school? How am I going to get to work? I mean, evictions really start a cascade of a lot of problems for tenants. So keep that in mind as we work our way through this. The good news is that there is some good news, and we want to talk with you about that. Let me now just sort of step back and introduce myself and Michaela. So I'm a partner here at Hunton. I've been here since 1985, and I had the good fortune shortly after I joined of having a mentor come to me and say, you need to get involved in pro bono. And more than just deliver the message, he said, come with me. I'm going to take you over to Central Virginia Legal Aid and introduce you to Henry McLaughlin. And he's going to get you involved in pro bono, which he did. And it's something that I've been fortunate to continue to do for 36 years. And I've done continue to do a lot of tenant representation on pro bono. I also am involved in our Churchill office. Hunton started a standalone office in the Churchill section of Richmond a little over 25 years ago that was designed to provide legal services to what we call the working poor, people who were who made more money or hadn't made enough money. They didn't qualify for legal aid, but really didn't make enough money to pay for private attorneys. George Hetrick, who was at the firm then, started the office, and it's been a freestanding quasi-legal aid office doing solely pro bono work for 25 years. And one of the aspects of that office is we hire basically every 2 years a new pro bono fellow, generally someone right out of law school who has a demonstrated interest in doing public interest work. And she or he comes to us and spends 2 years working with us and also working with Central Virginia Legal Aid, doing exclusively pro bono work, a lot of which is housing work. Our fellow, and Michaela reminded me that yesterday was her 1-year anniversary, so congratulations. Michaela joined us about a year ago, and because of because of COVID and the housing crisis and evictions, has focused a tremendous amount of her time, not exclusively, she's done a lot of other things, but has primarily worked on housing law cases in the year that she's been here. And we want to talk with you over the course of the next 15 minutes or so about evictions in Virginia. I'm going to cover the recent history of evictions in Virginia. Michaela's going to then talk about the CDC moratoria, the practical impact of that. I'll come back, then speak with you about current eviction protections. And then I think what may be of the most interest and use of all of what we have to say is Michaela's going to talk with you about Virginia's rent relief program. Then I'll give you a little bit of a case history of a case we had recently that rent relief really turned out to be a savior, both for the landlord and for the tenant. And then we can take any questions that you have. The history of evictions in Virginia, we think about it in terms of COVID, but really it predates COVID. Predates COVID by about 2 years. I mean, the focus on the eviction crisis. I know David Newmeyer is on the phone from the Legal Aid Society in Lynchburg, and our legal aid colleagues know that Virginia had an eviction crisis long before 2018, but it really came into focus in 2018 because there was an article that was published in the New York Times by Matthew Desmond, who's a professor at Princeton, who had 2 years before that, he'd written a bestseller called Evicted, which focused on anecdotal stories of people who've been evicted in Milwaukee and how they spiraled downward after eviction. And it got him so interested in it that he created something called the Eviction Lab at Princeton to really do a deep dive into the data that was available on evictions across the country. He did that, and in 2018, April of 2018, his group published their findings, and it was not a great day for Virginia. What it found was that of the top 10 cities in the country for evictions, Virginia had 5 of the top 10. And the Virginia cities were, Richmond was at the top. It was the #2 eviction city in the country. Hampton was 3rd, Newport News was 4th, Norfolk was 6th, and Chesapeake, Virginia was 10th. So we had 5 out of the top 10. He sort of did a deep dive in Richmond and found that 1 in 5 households in Richmond in 2016 faced eviction, and 1 in 9 actually were evicted. 1 in 9 households in Virginia went through the eviction process in 2016. That spurred a lot of people to get focused on the eviction situation in Virginia. And I hate to sort of single out anybody, because to single out anyone leaves a lot of people out, but 2 people who come to mind are Christy Mara at the Virginia Poverty Law Center and Marty Wegbright at Central Virginia Legal Aid. And they started to focus on what can be done with respect to the eviction crisis in Virginia, and specifically for them in Richmond. And some neat things got underway that we don't have time to go into, but there was Marty came up with an eviction diversion program that really was getting its feet under it when COVID hit. And you'll remember that COVID hit in March of 2020, and the courts shut down for the most part, which meant that a lot of eviction procedures that were ongoing at that point came to a halt. And there was great fear that once the courts opened back up, and in the interim people had lost jobs, that we're going to face a tsunami of eviction proceedings in Virginia. That tsunami did not materialize, in part because of the CDC moratoria. I'll stop at that point and turn it over to Michaela.
Great. Thanks, Chip, and nice to see everybody. So the federal government in 2020 put into place an eviction protection commonly known as the CDC moratorium, which has been in place with a brief break from 2020 until the end of August, just a few weeks ago. And that essentially acted as a backstop for evictions for non-payment of rent throughout the country, including in Virginia. And so the way that it worked was that a tenant could sign a declaration under penalty of perjury saying that they had lost income due to COVID, that they had done all they could to try to make partial payments, get government funding, et cetera, but they still weren't able to pay their rent. They would become homeless if they were evicted. And they had to sign the declaration, give it to their landlord, and essentially that would halt an eviction for non-payment of rent. So an eviction where the landlord says, the reason I get to evict you is because you haven't paid. And so in Virginia, that has been working as sort of a final stop on the, as Chip was describing, the sheriff actually coming to someone's door and taking them out of their home. It doesn't mean that eviction proceedings have stopped. It doesn't mean that evictions for other reasons have stopped, but it was sort of working as this final protection for tenants. At the end of the last week of August, the United States Supreme Court declared that moratorium unlawful. So that moratorium is no longer in place, and the federal protections, that final backstop, has gone away at this point. But the good news in Virginia is that we have some state protections that are actually stronger than that CDC moratorium was. I think Chip's going to get into those.
Right. So again, I think this is great testament to the work of our legal aides and Christy Mora and others. And I have to say that with some input and some assistance from landlord organizations, Virginia enacted legislation specifically targeted at trying to get us through this eviction crisis. There's law in the books now that has a sundown of June 30, 2022. So it'll be with us for a little over a year now, and perhaps longer if it's extended, that give the following protections to tenants. First of all, normally, historically, if a landlord wanted to start an eviction process, the first step was to give the tenant what was called a 5-day pay or quit notice, saying you're behind in your rent, you have 5 days to pay. If you don't pay, I'm going to start the legal proceedings. That has been extended to a 14-day pay or quit. And once the landlord gives the 14-day pay or quit, the landlord is required to start the rent relief application. And the landlord has to cooperate either with the tenant in putting the application in, or the landlord themselves have to put the application in. And once the application goes into rent relief, the landlord cannot take any further action to evict the tenant unless the tenant is found to be not eligible for rent relief, or the tenant refuses to cooperate with the rent relief process, or that rent relief comes back and says the tenant doesn't qualify. The eligibility requirements for tenants, again, I'm going to give you these on a high level. The household income must be at or below 80% of the area median income. The rent amount has to be at or below 150% of the fair market rent. And there has to be a loss of income related directly or indirectly to COVID-19 or increased expenses. And that last one is important, obviously, but it really, in its application, is very broad. To give you some idea, loss of income includes if the tenant's been laid off, if their place of employment is closed, if they've experienced a reduction in hours of work, if they have to stay home to take care of a child because there's been a closure of daycare or school, or if they've been unable to find employment due to COVID. There also, so you can either have loss of income or you can have increased expenses, and those include increases in childcare expenses and medical expenses and food costs or utility costs that can be related back to COVID. Not to sort of steal Michaela's thunder on this, but what's really important, so with those, that says, okay, you got to go to rent relief. Well, what does that mean? In Virginia right now, a landlord and a tenant can qualify for up to 18 months of rent. And that can be 15 months of back rent, 3 months of forward-looking rent, and it can also cover other fees, such as late fees. So with that, let me turn it over to Michaela, or turn it back to Michaela, to talk to you a little bit about how the rent relief program process works in practice. Michaela?
So the main headline, as Chip said, is there's a lot of money available for rent relief. It's easy to access it if the landlord and tenant can work together, and lawyers like you all and like us can help facilitate that. And it's a win-win for landlords and tenants. So Virginia, unlike in the sort of sobering statistics Chip was sharing, Virginia is actually leading the pack in terms of distributing federal rent relief funding. Virginia is the first in the nation in terms of the percentage of federal funds for rent relief that have been distributed and gone out the door to tenants. That's over 50% of the federal funds that Virginia had available. That said, there are still over $700 million left for rent relief, and that can go directly to landlords in their pocket. So there is a lot of money available.
And that's Virginia only, right?
That's only in Virginia, yes. So Virginia itself has over $700 million available for rent and for rent relief through this program. And so in order to apply, either the landlord or the tenant can start a rent relief application, and you can do that online. Either party can do it online. Essentially what you need to do is to just verify the requirements that Chip was just talking about. As this rent relief has been in place over the last few months, there are increasingly more staff members working at the rent relief program. You can get them on the phone pretty easily if you have any questions. There has also been funding put in place and people hired as rent relief navigators at local legal aids. So if you have, if you're working with landlords or tenants, the tenant can reach out to their local legal aid to get some help from someone who's 100% of their job is navigating this process. And, you know, like anything, it is more challenging the first time you do it to try to navigate the documents that are required and all of that. But the message is ultimately it's not that hard. I, you know, was just telling Chip, I had some tenants come in yesterday. They're in the middle of an eviction process. We worked together. It took 15 minutes for us to do the online application. I got them their income verification. I worked with the landlord's attorney to get the few documents that are needed from the landlord, their lease ledger, their lease agreement, the landlord's information to where the check should go, their W-9. And, you know, in a lot of these cases, there's a lot of interpersonal animosity between the landlord and the tenant. And so as an attorney, you know, part of our job in general is mediating some of that and helping resolve conflict. But especially in this case, it's relatively simple to help facilitate this kind of application and get this win-win situation for both the landlord and the tenant.
Let me give you just a brief case study and a chance to sort of further sing Michaela's praises. We, you know, in a lot of these landlord-tenant disputes, they get started because there's a disagreement between the landlord and the tenant about conditions at the apartment or the house. Sometimes that leads the tenant, as a lot of us might do, to say, well, if you're not going to fix it, I've asked you 3 or 4 times, I'm going to stop paying rent, which is not the right thing to do. You should go through a tenant's assertion, but again, that's another story. But we have a case, it's still ongoing, but we think it's about to come to conclusion. Very typical along those lines. Landlord and tenant had sort of fallen out about the conditions at the premises. Tenant had stopped paying rent. In the interim, they lost their job. The conditions is, you know, landlord was, I'm not getting paid, so I'm not going to fix anything. The sort of animosity between the landlord and the tenant got higher and higher. And we were heading for what really is the normal outcome in these cases, which is sort of, in my view, a lose-lose on both sides. The landlord was going to go to court with a UD, likely get a possession judgment for possession, which would give the landlord the premises back. So that is something for the landlord. But in this case, it was going to leave the landlord with many, many, many months of unpaid rent. Flip side, on the tenant was looking at being evicted, had nowhere else to go, had nowhere to move their possessions. And it was, you know, it was going downhill from that. Now, fortunately, there were 2 really important players to this, Michaela on our side and a really good lawyer on the other side for the landlord. And the 2 of them working together were able to convince, Michaela was able to convince our clients, and the landlord's attorney was able to convince the landlord that there was a win-win way out of this. And the win-win was for them to cooperate, apply for rental relief, get the rental relief, and have an orderly move out of the house. And that is how things ended up. And what could have been a situation where a landlord gets a judgment that probably they're never going to be able to collect on, and a tenant's left with their possessions on the street, turned into a situation where the landlord is going to be made whole and the tenant's going to be able to move out and on a reasonable and dignified timeline. And you know, that to me is what the message to get out to people, whether it's on the landlord side or the tenant side. With $700 million available, you know, there's a positive win-win possibility in these cases where there really wasn't before. And you know, we are still running up against some, not just mom and pop landlords. I mean, some mom and pop landlords don't know about rent relief or haven't been through it, which is understandable. But some of the big landlords don't know about it either and have sort of shied away from it. And we've taken a couple of the big landlords through the process. And once they've been through it, it's like a lot of things. Once you've been through it once or twice, it gets much, much more simple. And they've been going back to it. So there is in this sort of dark cloud of evictions and dark cloud of COVID, there's a silver lining here with this rent relief program. I do want to go back and just say to David, who's on the line, and Christy and Marty Wegbright and the others in the legal aid community here, I think they've done just a phenomenal job of working through the legislative process, working through the legal aid process to create a situation in Virginia that, you know, we've gone from, and think of that, I mean, really in the course of 3 years, gone from being the highest eviction city in the country, or the second highest, to now being the state that's handed out the highest number of rent relief funds. And that's really a tremendous turnaround. And there are a lot of heroes out there who are responsible for it. So I think with that, we'll stop. And we're happy to take any questions. I told Michaela that it may be that either she or I get a lot of emails after this for follow-up questions. We're happy to take those, happy to help anyone. If you hear of either a tenant's lawyer or landlord's lawyer who've kind of thrown their hands up and say, I can't figure this out, I will tell you, Michaela is the master of it now. She helped one of our lawyers who had not done any of this before, kind of mentored her, and this lawyer was able in 3 hours to basically work out a situation, get rent relief applied for, and save a tenancy. And maybe that's the last thing I'll say is open with a little bit of a pro bono pitch. I'll close with one. What really makes this process works now, it's not to say that tenants can't do it on their own, not to say that landlords can't do it on their own, but as Michaela said earlier, to help work through the sort of animosities that normally have built up when a landlord files a UD, we need more pro bono lawyers to step up. So if there's anyone on the call who's interested in doing it, or if you're in the position to, as I had a mentor of mine do to me, say, well, I want you to get involved with this, I'll take you down to legal aid, I'd urge you to do it. The legal aids are stretched incredibly thin right now, even more so than in sort of normal operating times. They need pro bono assistance. So if you're in a position to help yourself, or if you're in a position to nudge a colleague or a younger attorney in your office to pick up some pro bono cases, particularly landlord tenant, now's a great time to do it. Thank you.
Michaela, that's fantastic. Great information, great story. I really appreciate that. Any questions, David? I see you turned your camera on.
Richard, thank you. I wanted to add 2 comments and also congratulate Chip and Michaela for a terrific presentation. I thought that was excellent. We captured everything. The additional comments are that there are pro bono opportunities if you know nothing about landlord-tenant law and don't want to learn, just to help the legal aid programs respond to what are dozens and hundreds of phone calls we're receiving with our navigators now, just to call people back and say, tell them where the website is, what documentation you're going to need. Does not require an attorney to do that. You know, any law firm staff are able to help out on those things. So that's another volunteer opportunity. And then I'll mention also, every legal aid program in Virginia is providing this help. Some of us help landlords as well, including my program. Some have chosen not to. So that's a small variation you'll find, but there are lots of ways to help. Thank you again.
Thanks, David. Chip and Michaela, one quick question. Are there any limits to the number of times that a landlord can go back to the well and apply or reapply for rent relief, assuming all the underlying conditions still qualify?
Yeah, so right now, there's not, to my knowledge, and David, correct me if I'm wrong, there's no limit by landlord. So if a landlord rents 100 units, they can get rent relief for every one of those units. For each individual tenancy, currently the limit is you cannot receive rent that predates the pandemic, essentially, so from before April 2020. And I believe the current, as Chip said, the limit currently is 18 months of rent. So that can be 15 months backward looking and 3 months forward looking. I will say that amount has been increasing over time, so it's possible that they'll change the requirements and allow for 20 months of rent in the future. But that's the current limitations that I'm aware
Fantastic.
And right, the tenant, if tenant didn't exhaust that amount already, they can go back and apply for more. So it's possible.
Mhm.
Fantastic. Any other questions from anyone? Hearing none. Fantastic job, everyone. I really appreciate our speakers, Arlene, Paul, Jeff, Chip, Michaela. Great presentations. Thank you so much. Next month's presentation is going to be on not the first Friday, which I believe is the 1st of October, because the VBA has a ton of stuff going on, including the Labor and Employment Seminar and Virginia Beach. So we're going to do it the following Friday. So pay attention, keep a lookout for that, and see you all then. Have a great weekend.